Welcome to the next of our Burness Paull Employment Law Lab updates. My name is David Morgan. I'm a partner here in the Employment Law team at Burness Paull. I have a particular interest, some of you will be aware, on the law as it relates to trade unions and industrial action and industrial relations, which is why I've been volunteered to take this particular session today. I'm also joined by Laura Fitzpatrick, who's a senior associate within our employment team. And in the true fashion, Laura will continue with a few hot topic cases and any legislative updates, which we like to bring you up to date on as well with these Law Lab sessions. So on that note, this is probably the second, if not third, in a series of workshops that we are presenting to you all on the changes that the Labour government are proposing to bring forward under the Employment Rights Bill. So you may have attended an earlier session that touched on some of the key employee rights, if you like, the individual rights that we see, the big headline grabbing situations like day one employment rights and having unfair dismissal protection from day one rather than from 2 years. So lots of headlines on those changes, but equally, I think we've seen a number of headlines in this space around trade unions and industrial relations, which, as I say, is a matter close to my heart. So by way of an update, if you like, on where things are, the Employment Rights Bill itself was published back in October last year. We are monitoring it carefully. In fact, our in-house employment lawyer who looks after the updates for our team just sent an update round earlier today to say that it's working through the parliamentary process and following a consultation. So it was in public consultation, which ended on the 2nd of December. We are now at the committee report stage. So that was just announced earlier today. And we've effectively seen a markup of some of the tweaks to the legislation as it works through the governmental machinery. Not much, I'm pleased to say, has changed or being proposed to change so far on the trade union side, but a lot can still change along the way. And as meeting with clients yesterday, the key question, I think, on most people's minds is when are we going to see these changes? And the current thinking is we shouldn't expect to see changes coming onto the statute books before the end of this year. So we're looking at probably 2026. The only slight change I think that we might, or the difference I might say to the law as it relates to things like industrial action that we're going to come on to talk about, is that it could be quicker, it could be easier for reasons I'll explain for the government to make those changes. And you might see some changes coming through this side of the new year, but nothing to panic you as yet in terms of imminent changes. All of these proposals will have to work their way through the parliamentary procedures to get assent to come onto the statute books on fixed days. But as you will imagine, the Labour government agenda is very much aligned with the trade union movement. And I think we have in recent years seen a bit of a political decoupling from some of the major unions like Unite and GMB from relying upon parliamentary change and instead taking disputes, as Sharon Graham, the leader of Unite, says, to the workplace with the likes of industrial action. But now that Labour is in force, obviously they can do more. And as you might expect, the political agenda will very much shift from the previous Tory administration and look to give much more rights to the trade union movement. And it's perhaps for that reason, if I might say personally, I find this area of law interesting, not just employment law, but particularly as it relates to trade union and industrial relations, that, you know, what we are advising on and what we as lawyers and you as employers and HR practitioners have to deal with shifts quite dramatically depending on the societal views of the day or the political views of the day. And of course, it could be the economic views of the day with cost of living crisis and pay disputes, etc. So safe to say that our employment law team has been very active and very busy over the last 2 or 3 years advising on the whole gambit of trade union recognition, industrial action, collective bargaining, and pay disputes. So as we now see a new government, what effectively, in a nutshell, they will be seeking to do is unravel much, if not all, of the legislation in this space that had been brought in by the previous Tory administration. So unsurprisingly, the previous laws that we've been living with, and there was a huge overhaul of the law, in particular industrial action back in 2017 with the Trade Union Act of 2016, put simply, it will probably just be unraveled. So I remember, and some of you may have attended a workshop that I presented. I kind of did a roadshow of workshops on the Trade Union Act of 2016, and what I said, taking the Ronseal advert, does what it says on the tin. The Trade Union Act did not do what it said on the tin in any good sense for trade unions. The Trade Union Act of 2016 was designed to rein in a lot of the powers and make it more difficult for trade unions to do what they have philosophically set out to do, taking, industrial pressure to employers. So I remember quite a provocative statement in a slide I pulled up back in 2017, which was good for business. But I remember as a geekish employment lawyer in this space, feeling it was maybe quite sad that we might go through our entire careers without advising on strike action, industrial action in the world of HR. And there is a richness, I have to say, to your role in the world of HR when you have that trade union dimension. The added pressure of the unions certainly adds, and about it, and it makes the boardroom take notice. In my experience, it's more than just a grievance, if you like. It's usually very much a collective issue. I then scroll ahead, and we then hit the various summers and winters of discontent when I did another series of presentations where I stood corrected and said, well, clearly we are still seeing industrial action. So despite what the Tory administration, it was coalition-led initially with Lib Dems, but really was a conservative-led initiative. My provocation that we may not see industrial action, we saw a spate of industrial action up and down the country, didn't we? From junior doctors, from the local authorities, from barristers in London. We saw a huge range of industrial action, even though the Tories were making it harder for trade unions to mobilize strike action. So here we are now moving into the next era and the next political and societal shift with the Labour government in power. Rest assured, what they are, put simply, seeking to do bluntly is tear up the Trade Union Act of 2016. Okay, so they will be unraveling much, if not all, of what we have lived with and seen before. So really, as I now move on to my slideshow, what I will be presenting to you on effectively is the mirror image of what I presented back in 2017. So effectively, almost what we've been living with for the last several years will effectively be unraveled and go back to what we had before. So we're going to see quite a shift then, just going back to what we were probably most familiar with, for those of you who have been working in this space for a number of years, as I have done. So going back to that and then some, effectively, and then also relaxing the rules even more in some respects. So kicking off on that, there's three areas I'd like to cover in the course of this session. The first is the laws that relates to industrial action. Second, trade union recognition, the statutory regime for recognition. And finally, trade union law and rights, some more innovative approaches to dealing with those rights of trade union activists and members. So first of all, there's going to be a reshift on the turnout requirements for industrial action ballots. So if you faced industrial action, you'll know that there are very draconian, very strict ballot regime, and effectively helm-end the trade unions. If they get them wrong, you can seek an interdict in Scotland or an injunction in England if they fail. But the big change that I have to say I felt was a real benefit under the previous administration was to make these ballots more democratic. And what the previous government introduced was a minimum threshold turnout effectively to vote of 50%. So remember, only trade union members can vote. That's the law. Only a member of a union can vote, and each trade union must carry out a ballot themselves. So if you have multiple unions, each union must do so. So if you have only the union members voting in a ballot, what the previous law in 2017 said is you at least have to have 50% people come out and bother to vote to make them democratic. That will go. So what the government's looking of the day now is to unravel that and just make it again as it used to be, a simple majority of those who actually turn out and vote in the ballot for that to be accepted. Now, what you can get there is quite extreme, in my experience, scenarios. And it happened before, and it looks like that will be set to happen again. And I don't exaggerate when I talk about, if you imagine a workforce, a bargain unit, let's call it, that comprises, say, 1,000 staff. If you have low density of membership, and this is not unusual in some businesses who've traditionally always had a trade union, you might find yourself with 1,000 employees, of whom, let's say, only 100 are union members. Of those 100 union members, there's a pay dispute. They have the right to vote. Let's say in that scenario, only 50 people bother voting. And this is an important point. Apathy. But who are going to vote? The 50 people that will vote, rest assured, are most likely to be the union activists. Of the 50 people who vote, all they'll now need is a simple majority. So what's that? 26 people. And that's where I talk about the tail wagging the dog. You could find, therefore, a strike action, industrial action in a workplace comprising 1,000 people to take a simple single site workforce and having 26 people that set the agenda for shutting down the plant with industrial action. So quite extreme when you look at those numbers. And actually, I have to say, folks, not that unusual. Different if it was high union density and the numbers might be more democratic, but that is, I'm afraid to say, looks like that will be set to continue. There previously was a secondary hurdle in what's called important public services. They're quite restrictive: education, medical emergencies, a London Underground and London buses. So particular transport functions, etc. There was a secondary 40% turnout requirement that was also required for such important public services. And again, that will be abolished. So the Labour government are down on that, as you might imagine, and will wish that to be reduced as well. The second bullet point, again, I promise I'm not being political on this, but just from experience, it's disappointing to see that this point will be removed also. So the information required on the voting paper is to be, as the Labour government talk about, reduced and simplified. Now, that was always the case. All that you really had to do back in the day, when you filled out your tick your box, yes or no, you had to tell us, will it be industrial action, being strike, and or will it be industrial action short of strike, a overtime ban, a go slow, these kind of work to rule. That's going back to all you need to do. What the Trade Union Act of 2016 added was a little bit more detail, not forensic detail, but I think if I'm a union member and I'm casting my vote, I would like to know, what am I voting on? And it might just be pay. A pay dispute might be simple. It might be a change to hours, a pay grading system, etc. But what the ERB is telling us is, we'll just go back to basic principles. All you have to do is keep it simple. What are you voting, yes or no? So I guess I'm afraid I think that is also a retrograde step, both for the union members voting, but also for employers who want to get their message. And for that reason, it's so important in these difficult times of change with industrial action that you drive the direct communication message with the workforce. What are they really voting on? You're entitled to tell them that. Third bullet point, this will be quite chilling, I think, for folks, because as things currently stand, it might surprise you to know that the only way you can vote in a trade union industrial action ballot is by post. And if you ask yourself honestly when you last went to the post office to buy a stamp or to bother posting a letter, it's much fewer and far between. We do our banking online, we do our voting for X Factor, which is important, online. We do dating online. You do all sorts online electronically, but not your strike ballot. But again, that was something that the Len McCluskey under the previous regime of Unite was pushing hard for, electronic balloting. And it looks like certainly what the Labour government said is they will consult over that. But you'd imagine they would be more aligned to having electronic voting. And I think the significance of that is it will make it so much easier for people to vote. And we generally encourage our clients to get people to vote. You want it to be democratic, but of course the risk will be the activists will be pushing hard for that as well. And if electronic balloting takes place, whether through some kind of survey monkey type thing or even enforced through the Electoral Reform Society with a web-based platform, you could imagine you'll get a greater turnout. And that may be a good thing, but equally, I think probably that you could imagine that it'll be easier for ballots to get up and running if it's a simple click here rather than have to actually post your ballot back. Another one, it seems a small one actually, the period of notice. So this is what I call, maybe inappropriately, but the bomb warning. And it is like that. You get on a Friday afternoon, you get your notice of industrial action. That's a bomb will be going off in, it was 14 days for the last 7 years. Before that, it was always 7 days. It will go back to 7 days. So not a huge shift, but actually an extra 7 days can be a heck of a long time for you to carry out your business continuity plans. So that, as I say, that alarm bell of strike going off within 7 days rather than 14 will have a shift. Overall, when you look at the whole ballot period, you're still looking at several weeks from the notification of intention to ballot, carry out the ballot, then give the notice. So it's not going to be that you're hit with immediately 7 days. So it's not quite as panic stations as that, but unsurprisingly, that's another restriction that the government are looking to do. And then we have things like lawful picketing. And despite the photos and the videos you see online or in the news of some of the heated disputes, industrial disputes up and down the country, you're only meant to have 6 pickets lawfully. And a lot of that's ordered in the breach, which we will target very much from a legal perspective. But there was a new rule put in place where these pickets had to have union supervisors, they had to wear an armband, they had to notify the police of their presence. Again, it looks as though that will all go. Okay, that's not going to be an added legal requirement under the new regime. So just again, some unraveling of some of the old rules that we've been coming to look at. Another one not on the screen, you might remember the Strikes Minimum Service Levels Act. So that was around particular public services, again, largely in the south of the country, where that was a minimum level that the union still had to operate the service. That again is going as well. So all of these added thresholds are going to be going if these legislative provisions come in. And again, final point on the bullet point on the screen. This is a quasi-individual right here, but still under the collective regime for all workers. But until this comes in, actually, the current law, believe it or not, is if a worker takes part in lawful industrial action, and they don't have protection from detriment, and that will change. So again, if someone is picked on, if you like, for taking part in strike action, that gives them that special protection, and that we also have for the rule against dismissal. So you might be familiar as well that, again, this has been law for many years. You cannot dismiss striking workers or workers taking part in lawful industrial action. And that's different from wildcat strikes with no ballot. But if the union has balloted properly, has a protected reason for the strike, and all the workers taking part are protected from being sacked for 12 weeks. Okay, so that's the current law, very familiar, been there for many years. The proposal is to reduce that such that, or to remove that you always have protection from dismissal for taking part in lawful industrial action. Okay, so for as long as there's a mandate, and the current law is that a mandate lasts for 6 months. I've actually not seen any proposal to change that. And I might need to look into that more because I'm surprised. I'd have thought that might be lifted as well. But as the law currently stands, a mandate lasts for 6 months. So you can't be dismissing any employees. It's quite an unusual thing to do, folks. I've seen it threatened, but not done, because you have to really unselectively sack everyone. You have to dismiss all the workers taking part in industrial action, which is understandably a bold step. So added protection there for the workers taking part in industrial action. Next topic, so the second that I said I would cover is the changes as they relate to the law of statutory trade union recognition. So again, the historians amongst us that might remember this law came into force in 1999, or in fact 2000. It was Employment Relations Act of 99 and came into force in 2000. And this was the new Labour government of the time. This was the Tony Blair, Gordon Brown era, where having come into power as new Labour, understandably, you'd expect them to have more of an allegiance, this is post-Thatcher, with the trade unions. So what they stopped short of doing is giving a compulsory right to recognition. Okay, so it's not about a complete automatic right to recognition. Put simply, what the statute regime was designed to do was to identify an appropriate bargaining unit, a pocket of workers that was appropriate with the runnings of the business. And then, broadly speaking, if a majority of the workers wanted it, they can get it. And there was quite a convoluted set of legislation put in place. And if you've been in the receiving end of that, you'll know about it. It moves incredibly quickly. It uses the Central Arbitration Committee, which is the CAC, as the adjudication body to determine disputes around trade union recognition. But broadly speaking, there had to be a certain amount of support for recognition. And we've done a lot of work in this space really since the inception of the law. It's again very significant to a business. You'll know about it if a union comes knocking, and you're going to have to change everything about your employee relations culture by negotiating pay, hours, and holidays. They're the big 3, 4 collective bargaining. So that is not going to be removed, this law. It's going to be relaxed, but it won't go back to an absolute right to recognition. There still has to be threshold levels of support. But put simply, the government of the day claims that the statutory recognition process makes it too difficult for trade unions to gain recognition. So what they're looking to do is to relax some of these thresholds and make that easier. And it'll be interesting to see in practice just how much easier it will do. So the first headline-grabbing change that is being proposed is to remove the requirement right at the outset of the first stage of the application for the union to show that at least a majority, at least 50% of the workers are likely to support recognition. So what I tend to say, actually, I've said for many years, that the first threshold is quite light. All the union has to do is evidence at least 10% of the workers in the bargaining unit are members. And that's usually quite easy in my experience, the 10%, because they'll know about that, they know their records, and if they choose their bargaining unit carefully, often they go for a slightly smaller bargaining unit, the 10% is quite easy. However, the law is very clear. It says, and evidence that a majority would likely support recognition. Not on a ballot at that stage, not on a vote, but what we tend to see in practice is, and you might have experienced, you'll get petitions passed around. Okay, so there'll be signatures of petitions signed here. We look at them carefully when it goes to the CAC, because it might just say, would you like to hear more about the GMB? That's not good enough. It needs to say something more tangible, like, are you interested in collective bargaining for your pay? Please sign here. That bit will be removed as what's being proposed. So the government are effectively going to remove that. Now, I had a few cases over the last few years that actually greatly surprised me at how lax the trade unions were on that threshold. And we actually had some successful strikeouts of applications right at the early entry level because the union evidenced 10%, but they gave no evidence of majority. And the CAC were quite bold, actually, in knocking them back right at that first hurdle. So that bit will be removed. I think what we'll probably likely see more of then is bigger bargaining units. I think the unions might get a bit braver now to say we're going to go for larger bargaining units if we don't have to evidence right at the start that 50%. We can worry about that down the line when we get access to the workforce and try and drum up our numbers. The next removal is an interesting one as well. It's to remove the 40% threshold for support at the recognition ballot stage. So what that means is once the application's up and running, and once it eventually comes to a vote, now what I should say is if the union can prove they have 50% membership in the bargaining unit, then they get an automatic recognition. If they can prove 50% members, because the CAC tends still to take a presumption that if you pay your union dues, you probably want recognition. We've challenged that for clients over the years. It's a presumption that I argue is not completely natural because the people join a trade union for a multitude of reasons, for their advocacy, for benefits, and because they believe in the union movement. But with that in mind, it becomes, if there's not 50% membership, it turns on a vote. And these votes become incredibly heated. They are quite divisive. They're effectively run as campaigns by the union, and we encourage our clients likewise to appeal to the workers, to the hearts and minds, not anti-union, but rather why we think recognition is not right for this business if that's the instruction that we have. And effectively, this is going to be very similar, I think, now to the change that we're seeing in industrial action ballots. And what the government is proposing is you'll need is a simple majority of those who bother their backside to vote. And I do worry a little bit about that because, again, I'm back to the democratic right here. Back to the little scenario I gave before. What if you have a bargaining unit of 100 people and only 100 people, and it's, again, those who vote yes or no? In my experience, if you want recognition, you're going to vote for it, and that will be the union activists. If you don't want recognition, in my experience, employees don't feel that strongly about that, and apathy creeps in. And I think that's a major risk. If someone's not that bothered, they think, I'm not a union member. What will be, will be. It doesn't affect me. So I think that's going to be a challenge. If it's a simple majority, it will be easier of those voting, because you can rest assured those who vote are probably going to vote yes, and you're going to see how the majorities can be achieved. So the democracy there, I worry about, I have to say, because that 40% threshold gave 40% of the whole bargaining unit, whether you are a member of a union, whether you voted or not. So by removing that, I think it definitely will have an impact on making it easier for unions to get a foothold. And the final one, I mentioned this 10% initial threshold. The way that this is being structured is the law may change to allow the Secretary of State to reduce the 10% to as low as 2%. So again, that would be a very minimal de minimis entry level of 2% membership. To be honest, I find it in practice quite easy to get the 10% membership. That's not usually a huge number, but I maybe come back to my point. That might make the unions braver about widening the bargaining units if they only have to evidence 2% membership to get their case up and running. So that's the recognition regime, a complicated regime already. It will be relaxed. It will still be a very, very full-on process to go through, triggered by a simple letter. And as I say, you'll know about it if you've been through it, or brief us if that's the case. And the final section I'll cover before handing over to Laura is that the changes on trade union law generally. And I think probably for me, this is actually going to be one of the biggest changes that we will see. As the law currently stands, if you do not recognize a trade union, a union has absolutely no legal right to come into your business, to enter your premises, and bluntly to do what they want to do, which is recruit. And if you imagine going back to the previous slide, that's what a union initially will want to do. They'll need to drum up support for membership. And these campaigns that we see up and down the country are often very targeted. So a union will go for where they have their membership. And we've been successful in resisting applications for recognition for many clients on the basis that the bargaining unit is too fragmented. It sticks out on its own. You might have a network of 8 offices or 8 sites, and it's just one. And the union will say, well, that's where we have our membership. That's where we're targeting. And you can understand the reason for that. But the CAC tends not to like that. They want to look at what's compatible with the running of the business. So this will now enable, if this law is enacted, unions to have access to your workforce, to come in and to talk about unionization, the rights and wrongs of it, and how it might help the workforce. So they can come in and effectively canvass. Now, where you see that sometimes at work, I'm sure, is by a trade union activist, maybe someone who joins the business from externally where they're very used to being in a union. They might put flyers out, they might put notices on the notice board, they might ask to meet off-site, they might book a local venue and start drumming up support. You might see it at the factory gates, so to speak, with petitions and flyers being handed out. So this will make it easier because the union can make an application effectively to come in and to talk to your people. If you don't agree to it, surprise, surprise, the CAC will be stepping in there. So the proposal is to involve the CAC in these applications to agree effectively access arrangements to talk about recognition. So I think that's quite a major shift in the culture here for businesses. All of that said, where I would love to work with you on this is, despite the law currently as it stands saying you have no right to come into our business, I generally will encourage clients to meet with the union activists, maybe from HR or from a leadership level, to listen and understand what the drivers are for recognition. Okay, so that would be something I generally say, don't just block them because they'll just build a head of steam. I'd rather be respectful. We're not anti-union. We want to listen to you and understand and to gain information. The difference, of course, with this proposal is it's the workers that will be able to hear the message. There's also a proposal on the same vein to enable to entitle or to require employers to tell employees about the right to join a trade union. Okay, there's no law on that yet, but I often talk about the right to join a union or not because it's a personal choice. Some employers I know do that in the induction. They even give the trade union a slot in the induction process. So that's where there's a very heavy, maybe a good relationship, of course, a partnership approach. So again, I think that will be quite a shift if you're starting to have to say to your workers, you may join a trade union if you wish. I'll follow these up probably in writing with these, but there's going to be strengthening of the right to time off for union reps, access to facilities of union reps as well, and there's also going to be some added rules on equality reps for trade unions as well. So I won't dwell on those points. What I'd like to finish on actually is just some key actions. So as we have this window of opportunity, folks, I would say for those of you in a unionized environment where you recognize already this shouldn't have a major change to you, other than, of course, the mission creep. So if you have recognition in only some sites but not others, I think if there was any sense in the union movement, it would be about collaborating with such businesses to grow their foothold and to recruit in other sites. And that's where the access arrangements will be quite important to them. But more importantly, I think for those of you that do not currently recognize a trade union, you have probably a year, really, I would suggest now, to get ready for this and to be a step ahead of what might be coming around the corner. Because as you'll see, the unions, particularly if you're a large employer, particularly if you're high profile, particularly if you've already seen signs of unionization, attending disciplinary and grievance hearings, this all takes me back to 1999 and 2000. That's the classic recruitment campaigning. Look out for those early warning signs. And as I promise you, this is not about being anti-union. It's about doing the right thing by all of your people. But I think what we would commend to you is some upskilling of managers to look at training programs so people understand this stuff, to know what it means to work with a trade union, to know what their rights are, to know what the rights of your trade union members that are already in the business, to understand what concepts like collective bargaining mean. What are they? What's industrial action? Could it happen here? Could happen even if you're not recognized, as the unions can ballot their members regardless. So we are pulling together a pack, a training module, if you like, for all of our clients on what it means to work with a trade union, what the rights are of a trade union, and what your rights and obligations are as a manager. I think that's what's so important. Your managers deserve to be trained on this and to understand what the rules are. Because rest assured, when it gets this challenging and when there's conflict on the shop floor, they're going to hide away. You know, the human nature is, I don't understand, this is too hard. Or you may have managers themselves that are not engaged and that they agree and they think this is terrible and that we should have a union fighting for us all for pay. So I think this is a window I would say and suggest to you all for a year, really to get your understanding of what's coming around the corner with the law, because it does look set to happen and it does look as though we're going to see quite significant relaxation of the rules for trade unions and actually bargaining and pushing their agenda. So I'll pause there. I see that we had a question, so I will look at that, Laura, because I think it's directed at me, as I hand over to you, and I can chip in on
Yeah, of course.
the section, but I'll hand over to Laura now on the case updates.
David telling me that he would only need a short period of time. So yeah, thank you so much for that, David. And for the remainder of this afternoon's webinar, I'm going to run through 3 recent employment law cases and then touch on the proposed implementation of neonatal care leave and pay. So in the usual way, the full case summaries will be included within the written bulletins. So my focus for today is really just to bring the cases to life a little for you and draw out some of the kind of key practical tips and observations from these. So the first case update for today is Dexney v Ambitions Limited. This case is all about holiday pay liability. So in this case, the claimant commenced her employment in 2017, and she raised a claim for unlawful deductions from wages, arguing that she had been underpaid holiday pay. From April 2020, the holiday pay rules had changed, and employers were required to use an averaging 52-week period to calculate holiday pay for those workers whose hours varied. So I'm sure you're all kind of familiar with that concept, and it has given, rise to lots of people querying how their holiday pay has been calculated and whether or not there's a potential claim there. So in this case, the respondent did actually concede that it had calculated the claimant's holiday pay wrongly, as it basically hadn't taken the average payment and calculated it in accordance with the correct formula. So the claimant argued that she was due holiday pay from August 2020 and that such underpayments amounted to a series of deductions under the Employment Rights Act 96. So as you'll know, the 1996 Act permits deduction from wages claims to be brought within 3 months of the last in a series of deductions. The Employment Appeal Tribunal had previously held that a gap of more than 3 months between underpayments would break the series of deductions and essentially serve as a way to defeat claims in respect of underpayments before that gap. So the respondent in this case relied on this very point and argued that the claims were out of time as there had been a gap of more than 3 months between the underpayments, which therefore, in their view, broke the series of deductions. The tribunal did agree and held that the deductions were out of time as there was a gap of more than 3 months between them, and dismissed the claims. The claimant then appealed on the basis that the ET's decision in this case had predated the Supreme Court's decision in Chief Constable of the Police Service of Northern Ireland v Agnew, which had held that a gap of 3 months between underpayments does not necessarily, in every circumstance, break a series of deductions. So interestingly here, the Employment Appeal Tribunal upheld the appeal and determined that whether deductions of wages constitute a series is essentially a question of fact. And to answer that, you have to take account of all of the relevant circumstances. So that would include things like the similarities, the differences between the errors, the frequency, the size, and the impact of the deductions. And it basically, in this case, found that it was immaterial to that link, that the interval between the payments was from time to time more than 3 months. So in this case, as the underpayments were all based on the same calculation, which was incorrect, the Employment Appeal Tribunal found that they formed part of a series of deductions. And essentially, it didn't matter that one of the gaps here between the underpayments had been 7 months. So in this case, the claimant could claim for all underpayments going back 2 years. So I think from a practical perspective here, this case illustrates how an employer's liability for backdated holiday pay may be extended depending on the circumstances, of course. So our kind of strong recommendation when we're working with employers on these types of cases is to be alive to potential holiday pay claims, and if necessary, and you establish that there might be risk exposure of such claims being raised, to develop, a strategy for dealing with the same. That strategy is usually informed by legal advice, but we're often instructed to assist clients with reviewing how holiday pay is calculated, through kind of internal audits, usually with the help of HR and finance teams. And generally speaking, these types of audits can be, a pretty useful tool in limiting a company's potential exposure, being proactive to these types of issues and hopefully avoiding holiday pay claims, which can be pretty costly and time consuming, of course. So the next case on today's list is a Gallagher against McKinnon's Auto and Tyres Limited. So I think this is a really interesting case, particularly for today's audience, because it's all about pre-termination negotiation discussions under Section 111A of the Employment Rights Act, also known as protected conversations, and the extent to which these were disclosable during an unfair dismissal claim. So as I'm sure all of you are aware, pre-termination negotiation discussions, or protected conversations, as they're commonly named, are used by employers, consistently. And I have no doubt that many of you on this call will have been asked to either support with these types of discussions or potentially have them yourselves. So in summary, a protected conversation basically allows employers to explore with an employee whether their employment may be terminated on mutually agreeable grounds without the fear of anything that's said during that conversation being disclosed for the purposes of an ordinary unfair dismissal tribunal claim. So that's the default position, that anything that's said during these discussions is not admissible in an ordinary unfair dismissal claim. However, there is a caveat to that, and if there is anything that's said or done during such discussions that amounts to improper behaviour, the negotiations could be admissible to the extent that a tribunal considers that that's just. So there are, pretty few cases on the scope of the legislation and what amounts to improper behaviour. And I suspect that that's probably driven by the fact that most of these conversations do end up being, successful in the end, particularly if the settlement package that is presented, is favourable and reasonable in the circumstances. There are some examples that are given in the ACAS Code of Practice on Settlement Agreements about what might constitute improper behaviour, and they include things like harassment, bullying, or placing undue pressure on an employee to accept, the particular deal that might be presented to them. So, if you were saying to somebody that the dismissal or their dismissal is inevitable, if the agreement can't be reached, that would, perhaps be seen as being undue pressure. And as you'll probably all know, and when you're factoring in the planning stages of these types of discussions, the ACAS code does recommend that, as a general rule of thumb, employees should be given a period of 10 calendar days to consider the proposed formal terms of a settlement agreement and to receive independent legal advice unless the parties agree otherwise in terms of timescales. So in this case, the claimant had been on a period of sick leave, and the respondent had decided that the claimant's role had successfully been covered during the period of his absence, and ultimately that there was no longer a requirement for his role of branch manager. So the plan was to commence a redundancy consultation process on that basis. They scheduled a return to work meeting with the claimant, and at that time, the claimant was offered a settlement package in return for signing a settlement agreement. He was informed in the usual way that if he didn't accept the package, the respondent would go through a redundancy procedure, that being the alternative approach. So the claimant here was given 48 hours to consider the offer. He didn't accept the offer within the timescale and was then invited to a redundancy consultation meeting where they discussed his potential redundancy and the possibility of suitable alternative employment. After they'd done that, the claimant was ultimately made redundant and raised an unfair dismissal claim. And as part of that claim, he sought to rely on the discussion which had taken place at the return to work meeting, which was the protected conversation, as evidence of there being unfairness. The respondent argued that the discussions were inadmissible, and the tribunal agreed that the discussions were not admissible. The claimant then appealed to the Employment Appeal Tribunal and argued that the tribunal had been wrong not to find improper behaviour on the grounds that he had been told that his role would be made redundant if he did not accept the settlement package. He also argued that the respondent had placed undue pressure on him to accept the offer by failing to inform him of the true purpose of the return to work meeting, and with only providing him 48 hours to consider the proposal. So the Employment Appeal Tribunal did reject the claimant's appeal on this point, and found that telling the claimant that a redundancy process would commence is not the same as informing him that he would be dismissed. They found that it was clear that alternatives to dismissal would still have been explored and that that had been made clear to the claimant during the meeting. They also found that whilst it might not have been fair for the respondent to offer the settlement package at what the claimant thought was just a return to work meeting, this didn't amount to improper behaviour, as fairness was a different question, and not the test that the tribunal had to consider. And lastly, on the point around the 48 hours to consider the offer, the EAT found that 48 hours to consider a verbal offer did not amount to improper behaviour. So essentially, they drew on the fact that the code suggests that it should be 10 days to consider a formal written offer, but on this basis, it was a verbal offer and it was okay for the employer to have given the claimant 48 hours. Although they did know that it was open to a tribunal to conclude that the offer period, had been unreasonable in a different case. So it was kind of drawing on it being fact specific here. From our perspective, I think this is a pretty insightful decision for employers, and particularly employers that do use protected conversations, as a way of trying to agree a mutual exit with an individual. And it is a reminder that the test for impropriety is relatively high. I do think it's pretty interesting to see the distinction drawn between a verbal offer and a written offer, and also just the point around, presenting it as an option and not, a definitive, you're not saying that somebody's going to be dismissed. It's helpful from an employer perspective in terms of having these types of conversations with employees. And, as you'll all know, it's so important that these types of meetings are carefully planned and, typically scripted. We're always keen to help clients with scripting the messaging and making sure that, what's being communicated is appropriate in the circumstances. And I think, as part of that planning, what this case probably does underline is just, being aware that if you're working to strict timescales, plan ahead and make sure you're having the conversation at a suitable time with an employee. And just the final point as well is we often talk about, who is the right person to have this type of conversation with somebody, because I think often it's the delivery of the messaging and the way that it lands with the employee concerned that tends to kind of drive the success of reaching a resolution. So it's an interesting case, but from the employer's side, it's pretty insightful in terms of what would the sort of high bar for what would constitute improper behaviours. So definitely one to reflect on. And the final case update for today is Kurosi against University of Hertfordshire and another. So in this case, the EAT considered whether derogatory comments that were made about an employee's accent could be related to race for the purposes of harassment under the Equality Act. So in this case, the claimant was of Brazilian nationality and of Jewish ethnic origin. She'd been employed by the university as a marketing manager, and her position had a 6-month probationary period, which had been extended twice. The claimant resigned before completing her probationary period and brought several claims against her former employer, including claims of harassment and victimisation related to race. Her harassment claim centred on comments that were made about her accent by her line manager. For example, comments that were made during a meeting that the claimant had a very strong accent, that her accent was difficult to understand, and that this may pose an issue for the claimant in her role as a marketing manager. So in this, at the first instance, so the tribunal found that the comments were not motivated by race, but by the claimant's accent being sometimes difficult to understand, and dismissed the harassment complaint on the basis that the comments were therefore not related to race. As you'll know, that under the Equality Act, harassment occurs where there's unwanted conduct that's related to a relevant protected characteristic. The claimant appealed, and the Employment Appeal Tribunal upheld the claimant's appeal and essentially confirmed that the term related to should be interpreted broadly. The EAT found that comments about a person's accent could be related to the protected characteristic of race. So this case is, an important reminder just in terms of the scope of the Equality Act protections. And I know I'm sure you'll all know that many employers in the UK have turned or are turning their attention to the new duty to take reasonable steps to prevent sexual harassment at work. And as part of that, we're very much kind of encouraging clients to take a holistic approach to the new duty rather than a reactive and a piecemeal one. So for me, I think this case just highlights the importance for employers to, regularly review and update their anti-harassment policies and really deliver effective training across the board to ensure that, all of the workforce are mindful of, their use of language and how a claim for workplace harassment may arise. So that's the final case. And just before we finish up today, I just wanted to touch briefly on the proposed implementation of the neonatal care leave and pay. Again, this will be covered in full within the written bulletin that will follow after this, but in short, it's been confirmed that this will be implemented with effect from April 2025, subject to parliamentary approval. And the new entitlement will allow eligible parents to take up to 12 weeks of additional leave when their baby is admitted to neonatal care within 28 days of birth and remains in hospital for at least 7 consecutive days. So draft regulations have been published, and we will no doubt issue a blogger update once this does come into force. So that is the case update and legislation update for today. I think there's possibly a comment.
Yeah, Laura, so Veli's asked if you were surprised about the judgment and the distinction on 48 hours in Gallagher, and also drawing the distinction from oral or verbal as opposed to in written offers.
Yeah, I mean, I think, often when we are working with clients, and David, it is a case of like, we need to do this quickly, and but I would say I'm not overly surprised by that distinction being drawn, because I think often there's a sense of, take it away, have a think about it, and we'll follow up in writing with the proposed terms. And usually you would say at that point, you've got a week to 10 days to look at the proposed terms, whether just headline points in writing or by way of a settlement agreement. So I think it probably reflects the practical reality of what tends to happen in these discussions. But I think the other point, though, is just looking at the wider circumstances. So if it was, if there were other issues at play, and perhaps there had been, a more forceful conversation or something, then they might have found otherwise that a distinction shouldn't have been drawn between a verbal and written offer. But
I'm still a bit nervous, Veli, in putting things in writing with these stuff, and think the scripts are best done in a critical, protected conversation. And actually the classic as well, where here's a settlement agreement. I don't like that. I think that's too premeditated. The lawyers have already written the thing. So if I give anything, what I say is a prop is often maybe a without prejudice headed template that says, here's the deal. Because experience shows you don't take things in. If you're going through a horrible meeting like that, you're not taking it in, but at least you can go home, speak to your loved ones about, well, look at the terms I'm on offer. This is actually not a bad deal. And then you go ahead and take it to your lawyer. So mindful of timing, folks. I hope that was helpful. I hope there was some good nuggets to take away, both from the case updates and further legislative change on neonatal and on the Employment Rights Bill.